Okay, Shannon, put us back on, please.
Okay.
Your Honor, I do notice the Attorney General, there she is, never mind. Okay,
It looks like everyone's here.
yeah, I see.
So go ahead.
Thank you, Your Honor. I think that it's important to clarify the point that really kind of overrides much of what Ms. Hissong said. And that is that, are we to assume that when these drainage commissions were created years ago, that these folks didn't know where the water came from? Well, clearly they did. So for instance, when the Eaton County intra-county drain was created, they knew that there was a much larger watershed. So why did they create a smaller drainage district? Well, the answer is because the drainage district was designed to serve as a benefit to certain properties. And that benefit might not include all properties in the watershed. Let me give an example. Let's just say that in the Springbrook, the natural course of the Springbrook, and I know that it gets a little confusing because Lower Springbrook is actually higher on the map because it's downstream and it kind of works as backwards. But let's just say that there was a waterfall. Okay, so halfway between Jackson County and the Eaton County intra-county drain, there's a waterfall. So now they want to do improvements on the Eaton County intra-county drain. Does that benefit Jackson County because Jackson County is contributing water to that stream? No. Jackson County residents don't get anything out of that. What is impeding the flow of water from Jackson County isn't the Eaton County drain. It's 7 miles of unimproved water course that nobody is proposing a project for. Nobody is proposing an improvement for. There is not going to be any, that is what is preventing a benefit from flowing to Jackson County by simply making a downstream drain now an inter-county drain that encompasses 42,000 acres instead of 500 acres. And so the concept here that we can create an assessment district and make people pay to support this downstream drain when they don't get any benefit from that drain, and when there was no project, there's no improvement, there is nothing planned to change anything between now and in the future. They simply want to spread the cost, and Mr. Harrington, as chairman of the December 15 meeting, made that perfectly clear. The only point of this is to spread the cost to a larger number of people and to convert a county drain into an inter-county drain. That was the purpose. Now to do that, and again, under section 197, the statutory scheme is, well, that has to be just and equitable. The Drainage Board seems to be arguing just and equitable does not require any benefit to be conferred. That is an odd concept, I submit, Your Honor, that you could have no benefit, and they have attempted to articulate none, other than the fact that water flows downstream. But not a single benefit has been ascribed to this creation of this mega district. Not one. And yet, lands in Jackson County find themselves now part of a large special assessment district. That the whole purpose, as Mr. Harrington explained it, was to share the cost.
Can the individual landowners, including the County Road Commission, challenge any apportionment on that basis and say we shouldn't be apportioned any share of this because we're not benefited by it?
I suppose they can challenge their particular share, but the share for all of Jackson County's parcels has been determined. That's what the board did in its decision. It said we're going to add these lands, and here's how we're going to divide up the cost. And they said, I think it was 11% goes to Jackson County. So that has been done. Now, how the properties within Jackson County divvy up that has yet to be determined. But yes, Jackson County properties collectively will pay the amount that was apportioned to them. And that's where you get into the Section 106 appeal process, which by the way, deals only with apportionment between counties. And so that's not talking about, an assessment of this property or that property. It's talking about apportionment to the entire county. We're not challenging the apportionment, whether it was 11%, 42%, or 6%.
But if there's no benefit, wouldn't the argument be the apportionment should be zero?
Absolutely, Your Honor. Absolutely. It should be zero. But what we are saying is we shouldn't have been added, period. We shouldn't be part of an apportionment hearing.
Shouldn't have to go through this process.
Exactly, Judge. If there is this is a projectless project. This is an exercise to simply do an accounting change so that it benefits those people in the upper left-hand corner there that have to support the drain that they actually are benefited by, not the Jackson County people. And Mr. Snyder made the point at the hearing. He asked, what is the benefit to Jackson County? No answer. We're here today. What is the benefit to Jackson County? No answer. If in fact that 7-mile natural water course is the problem, as Mr. Snyder said, and as the affidavit of Mr. Ripstra indicated, then there is no benefit. There can't be a benefit. And yet they say, nonetheless, it is somehow mysteriously just and equitable that your lands be added and that you pay part of the cost of this downstream drain. I think it's important to understand that issue. And I'm sorry, the council can't just wave her hand and say, oh, it's fair. You had a chance to vote. Everybody had a chance to vote, so therefore it must be fair. It doesn't make it so. And I submit, Your Honor, that if you look throughout Section 197, it keeps referring to the boundaries of the lands benefited. So for instance, in subsection 1, the engineer is to, quote, lay out a revised drainage district including the land benefit. Subsection 2, he is to revise the boundaries of the drainage district to include all lands benefited by the drains benefited. Subsection 4, more accurately, the necessity hearing must more accurately define the boundaries of the land benefited by the drains. And finally, Section 5, if the drain commissioner or drainage board finds that the addition or deletion of lands will more accurately define the boundaries of the lands benefited by the drain, it would be just and equitable. And it would be just and equitable, then they can change the boundaries. So this concept of the lands must be benefited is embedded in the very Section 197 on which the drainage board relies. You have to have a benefit. You cannot charge landowners or an entire county and a portion of an entire county costs for which there is no benefit derived. The mere fact that they are in a watershed does not translate to a benefit. And here we have, by admission, no project, no improvement, and no determination, interestingly, of necessity. There has been no determination that this district is necessary. It was simply, as Mr. Harrington said, an allocation mechanism. I'd like to, and so I guess as an overview, just because of an observation, I think this concept of benefit is not one that's foreign to the drain code. And I'll admit, the drain code is hard to read in terms of its various inconsistent provisions and layers upon layers upon layers. But even within Section 197, I believe the concept of benefit is there. It was presented at the December 15 hearing, and we have a right to go forward. So let's look at jurisdiction. Section 197, according to the council, the drain commissioner is not allowed to use the first sentence of Section 7, but of course the Meads are. And the response to the Meads is, well, it's not ripe yet because you actually haven't been assessed. And I submit, Your Honor, that the mere fact that they are now part of a special assessment district, and that entire district within Jackson County has been apportioned cause, they have standing to sue. And this statute says they can go straight to district court. I'm sorry, circuit court.
And the aggrievement of the Meads, the named plaintiffs, is we're not benefited by this.
Well, we're subject to future assessments.
We shouldn't have been included in the first place.
That's absolutely correct. It's absolutely correct. And the county in which my lands are located already has been apportioned. So somehow the county is going to have to divvy this up amongst us landowners. And the fact that I'm in the special assessment district means my property is now subject to a burden, if you will, that I don't get any benefit from. Zero benefit. So clearly the Meads qualify. I actually think that the first sentence also applies to the drain commissioner as an officer of the county. He is here in his representative capacity for the county, who was apportioned, or which was apportioned, I should say, a share of the cost of this drain. And if not the drain commissioner, then who exactly would be here to speak for the county? And so you have that issue in terms of standing. But let's take a look at, if counsel were right, and let's just say the second sentence is the only way that the county can appeal the addition of land. If you look at section 106, it only applies by its terms to apportionment between counties. So yes, if we wanted to challenge the 11% number, we could go under section 106. But we are challenging the fact that we were added, that Jackson County lands were added, period. We should be entitled to appeal that decision. And I submit, Your Honor, that that is provided for in the first part of subsection 7. If not, then we have to ask ourselves the question, well, then where do we get the right? When do we get to go to court here? And we have submitted that under the Administrative Procedures Act, this hearing was essentially a contested case because they took evidence, there were parties named, the quasi-judicial determinations were made regarding the parties' rights. And under the APA, we should be entitled to appeal. Or under the Revised Judicature Act, under section 631, a final order is appealable to the court. Interestingly, counsel suggests that, well, you can appeal from this arbitration board. I don't see that in section 106. Where does it say that we can appeal from an arbitration board hearing? What it says is we have 10 days to appeal from the order adding land. Now, did the March 18 order add land? Yes, it did. And so what the Intercounty Drain Board would do is put us in a catch-22 where we're too early to appeal that decision, but then we're going to be too late to appeal the order if we wait for the end of the arbitration proceeding. Moreover, Your Honor, this is going to create a morass. What we have here now, according to the Intercounty Drain Board defendants, is the Meads can go to circuit court. Ultimately, whether it's now or later, they can go to circuit court. Jackson County Drain Commissioner, they say, has to go to arbitration. What do we do when you, as the circuit court, and the arbitration board come up with different results? Or even ask this question. According to counsel's interpretation, if the expansion of lands in the drainage district had occurred only in one county, then he could go to circuit court. But if it expands into more than one county, then you have to go to an arbitration panel from which I don't see any appeal right to circuit court. So you've got these kind of bizarre different processes that can yield inconsistent results with, frankly, no logical reason as to why expansion within a county would go to circuit court, expansion beyond one county would go to an arbitration board, when we're talking about a section of the statute that speaks not of expansions, but of apportionment. It's a numbers thing. They're not looking at whether or not there is a benefit conferred. They're talking about, was your percentage right? So we are essentially being placed in a no win, no appeal situation where if we appeal now, we're too early or we're not allowed. And if we appeal later, then it's too late. Even though there is no provision in either of these statutory sections that says we get to appeal then from a arbitration hearing. I think that there has to be an avenue to go to circuit court. Under the state constitution, there has to be from administrative decisions. And I think that the fact that, Ms. Islong explained or at least tried to explain her comment to the Intercounty Drainage Board at the hearing. But what she said is only Section 106, or Section 106 only applies to the apportionment decision. I agree. That was the correct advice. That was the correct advice. And I think to rule otherwise leads the court to this kind of mishmash of where do your appeal rights come from and how do you reconcile potentially inconsistent results, Your Honor. And I think that really is what this comes down to. I don't think that the process that we are advocating does violence to the statute. I don't think that it is inconsistent with the fact that this drain commissioner is a representative of both the county and the lands located within the county who are going to be will have been apportioned costs from this drain. I think that the other thing that needs to be pointed out here is the concept of benefited and of what is just and equitable under a decision, when a decision is made under Section 197. That these are concepts that are not just new to Section 197. That was admittedly a more recent, I think it was 2013 amendment. It finds itself throughout the drain code in terms of when you create an intercounty drain. And though defendants deny that they created an intercounty drain, I don't know how you can actually square that with what happened. There was an intra-county drain. There now is an inter-county drain board. How is there not created an inter-county drain? Yet they concede they have not gone through all the steps to create an inter-county drain. And those are both procedural, Your Honor, and substantive. There are whole chapters dealing with the creation of an inter-county drain. And maybe there's some semantics that I don't understand, but when we didn't have a Lower Springbrook Intercounty Drain Board before and a Lower Intercounty Drain District before, but now we have one, in my mind, that means this board created it. And we have to follow those procedures in order to safeguard both the substantive and the procedural rights of the landowners and the counties involved in the creation of this new district. And I think the fact that the sections of the code always keep referring back to properties and counties benefited is why you have the processes and the guarantees that you do. So
let me stop you. So land is benefited from a drain when that drain allows water to drain from the property that's benefited. That's the benefit?
I think that's what they're saying. I mean, if the water goes through the drain.
No. I might have asked it wrong.
Maybe I misunderstood.
I'm thinking back to a specific drainage issue I was involved in when I was practicing law, and a drain commissioner was involved. We had some upstream owners whose basements kept flooding. And in that case, my client's property was also flooding. We got a drain established, and those people upstream were benefited because theoretically, I don't know if it worked out that way, their basements wouldn't flood anymore.
Perfect.
They were benefited by this drain.
That's right.
Because it kept their basements from flooding.
That's right.
In the land that's in Jackson County that they're seeking to include in this drain, their basements aren't flooding. Their land is draining just fine with or without whatever's happening way downstream near Eaton Rapids with this red section of the of the property.
To actually extend your analogy, people's basements were flooding. They made an improvement. There was actually something done. Physically, something happened so that their basements would no longer flood. Clearly, in that case, yes, they are benefited. Now let's look at this situation. Because we are isolated by 7 miles of stream, and that is what restricts, to the extent it does, the flow from Jackson County. Do whatever you want at the mouth of Springbrook. Not going to affect us a bit. If our basements were flooded before, they're still going to flood. And if they weren't flooded before, they're going to stay the same.
It's not going to let any more water flow through that unimproved portion of the stream than is already flowing.
Exactly. And most importantly, it's not going to allow one drop more to flow at the outlet of the existing Springbrook inter-county drain, most of which is in Jackson County. Not one drop is going to flow faster. We're not going to get a single benefit from that. So for instance, if we take Ms. Hislong's example of why is it fair that people can be in multiple drain districts? And her answer was, well, some people don't benefit. If my property's over here, but you're improving a drain over here, I shouldn't pay for that. Why? She said, because there's no benefit. That's my argument. That's exactly my argument. Only people that are actually benefited and a finding of benefit is made, or if you will, a finding of necessity is made, that they should then be included in this large district. It's implicit in her argument. It's implicit in the code. It makes no sense to add lands that derive no benefit, but say, yeah, I know, tough breaks, you still have to pay for the folks that are benefited. It didn't work for, so for instance, in some of these other drains that were named, intra and intercounty drain, if there were improvements in those drains that did not benefit other parts of this large new drain, then what she's saying is they shouldn't be obligated to pay for those improvements. I agree. Couldn't agree more. So why doesn't that same analysis apply then to Jackson County and the Springbrook intercounty drain, where you can make all the drain improvements at the mouth of Springbrook you want? Not going to help us a bit. And that's what Mr. Snyder said at the hearing. That's what the 2 affidavits that we submitted, and by the way, they did bring this motion under C10, so affidavits are appropriate, that there is no benefit. And have you heard one articulated? I have not. I've read the briefs multiple times. I've read the transcript. I kept waiting for where is somebody saying, yes, here, Jackson, is how you gain out of this whole thing. This is why you need to pay money. It's not there. It's not there. And you can't simply by fiat say, well, your water flows through this drain, ergo, you benefit. Under that analysis, Ottawa County's got the ultimate trump card because the mouth of the Grand River goes through Ottawa County. So they could create a couple hundred feet of the Grand River as a drain and cess 18 counties in lower Michigan saying, oh, your water goes through our drain. It has to be benefited. Those properties all have to be benefited. My waterfall example. If I'm upstream from the waterfall and you're making an improvement downstream from the waterfall, I'm sorry, that's not helping me. Well, essentially, this 7-mile section is the waterfall. It is what prevents us from gaining a benefit. And unless we actually hear it, and I think the court should hear evidence, is there evidence that we are actually benefited? We never heard it in the hearing itself, the December 15 hearing. We haven't heard it in any of the briefing. What we're told is we don't have to show a benefit. And I submit that is wrong.
Well, I would assume her argument would be, you can make that argument, but you got to make it under subsection, under section 106.
That I can make the challenge?
Yeah.
She says that, but if I look on section 106, it talks about apportionment. I mean, first of all, I think that the drain commissioner can serve in the first sentence in subsection 7 of 197 as a representative of the county. Second, the Meads have a right as landowners to go straight to circuit court. Third, the second sentence in subsection 7 takes me to a statutory section that is asking me to challenge something I'm not even choosing to challenge. I'm not challenging the apportionment at all. So why should I go through an arbitration proceeding to challenge something that I'm not challenging just to get to circuit court? There's nothing in here that says that this arbitration board is empowered to, for instance, address all the issues that we've just talked about, whether there's a benefit derived, whether or not these 7 miles of natural water course have prevented or will prevent any benefit, particularly when there's no improvement proposed. Indeed, the benefit of the Lower Springbrook Intercounty Drain was, I submit, exactly as Chairman Harrington said. It was to exclusively benefit that red drain at the top. That's what it's intended to benefit. Not us. Maybe it benefits some other drains, but not us. And if we don't have a right to go to court, and other than to go through some bizarre process where we maybe are even actually forced to challenge an apportionment that we don't want to challenge, that makes no sense, Judge. And it makes no sense that the Meads can come right here and Mr. Snyder's got to go through this bizarre process so that we can get the possibility of inconsistent results. It just doesn't make any sense. It just doesn't make any sense. I think that.
So what of the argument that the legislature did a terrible job of draftsmanship, but that's what they did?
Well, if we're just going to say then what the legislature said, okay, then fine. I shouldn't be forced to go through an apportionment hearing to challenge just whether you added my lands. I mean, I don't look. I'm not going to defend the drafting of this statute. It's not the way I would have done it, and I think there are. I will admit there is some ambiguity created. All I'm saying is, by saying that, well, that's what the legislature said, the legislature then directs me to a process that doesn't make sense. It doesn't cover what I'm trying to accomplish here. That's another good point. It eliminates our due process. I mean, at some point in time, we ought to be entitled to challenge, was this fair and equitable? Now, I submit that that is part and parcel of the question of benefits. But at some point in time, we should be able to go to court and say, this is a violation of due process. We didn't get a fair shake. This wasn't a just and equitable allocation. And
a just and equitable allocation would have been 0% to Jackson County.
Exactly. And not include the lands at all. I mean, why include lands if you're going to make it a 0? But here's an interesting dichotomy. Okay, so the engineer that was required under Section 196 to define the boundaries of the watershed, which was deemed critical to this definition of the intercounty drainage district, included Ingham County. Now, by apparent fiat by the board, they decided it's only a few acres. It's going to be it's going to be really burdensome. Let's just carve that out of the district, as though by fiat we actually changed the watershed, which we did not. If they wanted to do it right, what they should have done is include them in the district, apportion them 0. But they didn't do that either. And so here we are. We were apportioned a share. We derived no benefit. We submit we were denied due process because when we asked and presented the question of how is this just and equitable, how are we benefited, no findings were made. No evidence was even presented as to how we were benefited. And yet this is the proceeding that ultimately determined your lands needed to be added. There is the larger constitutional question, and that is you cannot assess properties without that property being benefited by whatever it is that you're being assessed for. It's the case we cited on the bottom of page 10, Lansing versus Jennison. And I submit that we have a right to challenge the due process of even being included in a special assessment district, Your Honor. Let me make a couple more comments, and then I'll certainly answer any more questions, but I don't want to belabor the point.
In your pleadings, do you challenge the constitutionality of the statute itself as it's applied to these circumstances?
Yes, we do. We do. And that's the equal protection claim. As to the due process claim, it's a challenge to this proceeding itself. That we were denied due process because there was no finding made, there was none even attempted as to how or why we are benefited such that it would be fair and equitable to make us pay. And so they are different in that sense. But yes, the equal protection challenge is a challenge to the statute itself, the way it comprises the voting power of the board. And the fact that it has not been challenged in lo these many years, I guess I would maybe turn that argument around and say, well, for lo these many years, the Eaton County intra-county drain was never sought to be expanded, even though I'm pretty sure they knew where the water came from. So on that basis, that shouldn't be revised either. We have a right to challenge the equal protection basis. I will admit, I have not been able to find a case right on point. And I suspect if Mrs. Hong had found one, she would have pointed it out too. I think that there are analogous situations where they talk about voting rights being diluted because of geographic location. And I think clearly where you've got 17,000 and some odd acres in one county and 74 acres in another county, but they're both given the same vote, that doesn't sound right. That is a violation of equal protection. And I think we should be entitled to proceed on that claim and at least present the law to the court as to why, and analogizing to other court cases, both federal and state, that this is a denial of equal protection. That there has to be some kind of proportionality in the voting. Otherwise, the tail wags the dog.
So in a wholly intra-county drain, is the drainage district defined by the watershed, or is it defined by the lands benefited within the watershed?
The latter. Absolutely the latter. It's not, there is nothing in the drain code that says the drainage district must consist of the entire watershed. I defy council to show me where that says that.
But that's in effect what they've done here.
That's in effect what they're saying. Yes, that is exactly what they've done.
With the exception of the little bit in Ingham County that they excluded.
They just by fiat say that it's no longer in the drainage district.
You're part of the watershed, therefore you're part of the drainage district.
Right. That's exactly what they've done. And the engineer at least purported to say these are the boundaries of the drainage of the watershed. Ergo, all of you are in. All of you. Even without any attempt to say, and all of you are benefited. So it was in your two options, it's the latter that they're doing, or they should do. They have to find a drainage district that has to be defined by the land's benefited. And you can't escape that. You just simply can't. Yeah. Schneider reminds me that in the Lansing case, the benefit comes from a project. It comes from some improvement, some physical change, rather than just an accounting ledger change. And that's all this was. That's all it was purported to be. Mr. Harrington said so on the outset.
Well, but what Ms. Hisson started out with arguing was that back when this drainage district was first created, they didn't include all the lands benefited. And now the purpose of the legislation is to allow you to go back and now include them.
I have no quarrel with the fact that you ought to be able to revise a drainage district or expand a drainage district to incorporate the lands that are benefited by that drainage district. And for instance, if this had been a project to improve the 7-mile unimproved water course such that water drained more easily or better out of the outlet of the old Springbrook Inter-County drain, fine. That's fine, but then you go through a necessity process, you determine whether the project is necessary, whether the lands are actually benefited. You go through these substantive processes for creating an intercounty drain. None of that happened here. And what we're being told is we can circumvent all of that. We can simply say we're going to add lands, we're going to vote them up. If the vote is such that your lands are included, you're done. Can't go to circuit court, county, and you got to go to an arbitration process that deals with arbitration. That in of itself would be a violation, I submit, of due process. That you have basically and arbitrarily just said a watershed equals equal benefit. Maybe not equal benefit, but benefit. I'm not saying that they said it's equal benefit, but they have said that it's benefited.
Well, we are running out of time, folks. I'd like to give Ms. Hissong an opportunity to respond. I'm not going to be able to give you a decision today, but I would like to give her a few minutes to respond.
Thank you, Your Honor. I want to talk a little bit about the procedure and why it has to be the method I laid out, because the method Mr. Donnell suggested would create a morass. I haven't used that word in a long time, so I'm going to borrow it from him. So you have to get the county percentage and whether a county is in or out done before the property owners can appeal. Otherwise, that creates chaos. That's why we have the arbitration board right away within 10 days of the addition of the county. Now, Section 197 sub 7 says in the same manner as provided in 106. That means you use an arbitration board. It doesn't say exactly and only for apportionments. It says in the same manner as provided in Section 106, which means you use an arbitration board for an appeal of whether a county is in or whether a county is out. That's very clear. And so an appeal of whether a county is in or county is out has to get figured out, and the percentages before any of the property owner appeals can happen. Okay, that's why you do that first within the 10 days to an arbitration board. It doesn't go to circuit court because it deals with this concept of benefit at a county level, and disagreements between drain commissioners go to other drain commissioners. Once it's decided whether a county is in or out and what the percentages are, then that goes to, we don't know what anybody's assessments or anything are going to be, or even let's say the arbitration board says Mr. Snyder's right. Then there's no need for the Meads to appeal in circuit court. That's why we wait until after that second hearing and we get this county business taken care of first through the arbitration board. So you have to wait. You have to wait till the arbitration board proceedings are done before you go to the circuit court through that second hearing. That's why it's set up that way. The opposite, the way he's suggesting, would create chaos. So if the in or out counties and the percentages which they're not appealing goes to that arbitration board, after that's settled, then there's the second hearing as the percentages within that county, because we've already dealt with that at the arbitration board, and then you can appeal what percent, what your portion of within, let's say the 11% that goes to Jackson County should be. You're correct, and they are correct. I can't, as an Eaton County citizen, which I'm not, but let's say I am, say that Jackson County should pay more and I shouldn't pay any because everybody in Jackson County should pay. That would create a morass. You have to decide whether a county's in or out and what the percentages are of a county before you can decide anything else. That's specifically the way the legislature has set it. In any other section of the drain code on intercounty drains, that's the way it's set up in chapters 5 and 6. A person in one county can't appeal the assessment in someone of another county or say the other county should pay more. That's only between the drain commissioners. That's not new to section 197, and it is not a due process or equal rights violation, because if you read Alba County versus Gratiot County Drain Commissioner, it's only equal protection only happens at the assessment. You are correct. The drain commissioner can't appeal the decision of the arbitration as a manner provided in section 106, because section 106 specifically says that's final and conclusive. Every drain case you'll ever read says drain code proceedings must move swiftly because we're dealing with a public health issue. And so That's a swift moving, 10 days or you're done. We have to move on to the next process because we're dealing with flooding. So I think that it's done that way, not moving my hands to make it look pretty. I wish my life was like that. It's done that way for a very specific reason. You have to decide the county and the percentages before any property owners can get involved. The majority of Mr. Donnell's argument is about the concept of benefits derived. Thank the Lord that the Jackson County Drain Commissioner can only assess people who you can prove their basements would flood if an improvement wasn't happened, because that is not how it works. Benefits derived can mean your use of that. Your water has to go somewhere and you're using that public outlet. So the question, Section 197 is based on no improvements. So to read Section 197 would say the legislature was basically stupid to create a situation where you can change the assessment district with no benefit, with no improvement, because that's precisely what the legislature did. And I agree with them. The question of benefits derived is, does the drain, not the drain improvement, provide a benefit? So if you block up at the line where the Lower Springbrook Intercounty Drain is, and you put a big wall there, now let's see who floods. It's not the improvement, it's the existence of that drain itself. And it's not just who floods, it is who contributes. If your property, Judge, is on the top of the hill, you would argue that you would never pay. Of course you do. You are contributing water and that benefits. It is not defined in the drain code, benefits derived, but it is different in each situation. The Jackson County Drain Commissioner doesn't like it, but Calhoun County is in the same situation as Jackson County, and he voted yes. The professional engineer took the arguments of the Jackson County Drain Commissioner and made the recommendation that it does indeed benefit. The Eaton County Drain Commissioner says more lands in his county than what was just assessed before benefits. The Department of Agriculture, the chair of the board, also agreed. That's the purpose of the arbitration board. If the drain commissioner doesn't like it, he should have taken it to the arbitration board, and he didn't. Benefits derived is more than a flooding basement, a lot more. So that's why we have to take that to the arbitration board, get that taken care of first, then we can send it out to the counties, and then and only then do we deal with the property owners at that one basis of what is your percentage within your own county. It would create absolute chaos to have it in any other situation.
All right, well, thank you. I have a much better understanding of the issues now. Now, as I go back and reread your submissions, they'll make more sense to me. So I appreciate all of the arguments today. Ms. Allison Yoakum, I haven't given you an opportunity to speak. Is there anything you'd like to add to this debate?
Thank you, Your Honor. First, I would concur with Ms. Hissong in her argument. I think that she has properly told you how the drain code is interpreted across the state. But the Department of Agriculture is an improper party in this matter. The action here is really against the action of the drain board itself. And I think that that was recognized by plaintiffs in their response that they would be willing to stipulate to dismiss the director of the Department of Agriculture. This court, one, does not have jurisdiction over the director of the Department of Agriculture. Jurisdiction lies with the Court of Claims for any injunctive or declaratory relief. Number two, there's not been a lot of argument on this point today, but we don't believe that this has been set up as an appeal under the Administrative Procedures Act or under the Revised Judicature Act. The provisions that are in the court rules for how you would go about those have not been complied with. Regardless, however, it sounds like plaintiffs are willing to dismiss the director, and if that were the case, that would be fine with the director of the department.
And Your Honor, as we said in our response to counsel's brief, we added them as permissive parties, not as necessary parties. If they want out, fine. If any of the individual drain commissioners want out, that's fine. We only need, and we're only seeking relief from the Inter-County Drain Board. So if the Calhoun County Drain Commissioner wants out or the Eaton County Drain Commissioner wants out, that's fine. We added them because we thought they were interested in it, and under the court rule, there's both necessary parties and then permissive joiner. We joined them because we thought we'd be accused of not joining them if we didn't.
All right, fair enough. It sounds like that takes care of that issue. So, thank you very much. I will take this under advisement. If I decide I want some supplemental briefing, I will let you know of that. If I feel like I have enough here to render a decision, I will do that.
Thank you,
Thank
Judge.
you, Your Honor.
Thank you all.
Your
Have a good day, everyone.
You too.